Hello and welcome to a special edition of Real Life Architect. My name is Neil and I've been running my own architecture practice in the UK since 2009. I specialise in altering and extending private homes, and this channel is about the reality of that kind of work. Today I am speaking with Chris Whitehouse. He is a planning consultant and runs his own YouTube channel called Next Phase. I've put a link in the description below. Chris is a specialist in the planning application system, and today we will talk about house extensions, permitted development, listed buildings, self-built houses, and planning appeals. Stay tuned to learn everything you ever wanted to know about getting planning permission. Chris, thank you for joining me today. Your channel is packed full of useful information about the planning system. Who is your typical client?
Usually, therefore, a client profile that's a developer. It's sometimes sort of an investment group, and on occasions it is a singular sort of individual that's decided to take on a larger planning scheme. And then when it comes to appeals, we do everything, right? We cover off householder appeals as a practice right the way up to public inquiries. And then the High Court system as an expert witness. So I suppose that is the world's most long-winded answer, is saying that our clients pretty much cover all breadths of different types of applicants. But yeah, I suppose the only applicant that we don't deal with day to day often is sort of an individual or a family that are looking to do an extension for a home as part of a planning application. We take that appeal on if the application failed, but we rarely do this side.
That's where I've used planning consultants myself. I haven't recently done an appeal of a house extension, but if it came up, that's what I would advise my clients to do. I wouldn't take that on myself. It's a specialist area. You only get one shot at it. You better just hire someone like yourself to do that. So that's where I would see myself interacting with someone in your profession.
It's only in scenarios where a permission isn't forthcoming, or in a scenario where, for example, the application fails because of something specific to do with the listing rather than planning policy itself, that we would get involved in that. But certainly it would be a scenario whereby if your application failed and you needed to appeal, that's a different system. And in most scenarios where you're proposing extensions, etc., things have gone wrong, we're the people that you would contact to do that specialist case, and we have a decent reputation for it in the marketplace as well.
Good. I often find homeowners have a fear of the planning system. What would you tell the average homeowner to set their mind at ease about the planning application process?
The notion that someone has gone through sort of a horror story in terms of a planning application gone wrong is more likely to have made its way into sort of Google and been presented in horror stories than cases that have gone well. So I think in most circumstances, the planning system, especially when it comes to sort of the householder extension system, is actually quite straightforward. And in most circumstances, it's pretty straightforward to understand what would and wouldn't be acceptable in planning policy terms. Now, that line tends to blur sometimes in some locations with some properties. But I think in most circumstances, if you're looking at, let's just say, doing a rear extension to your existing property, I think what you'll find is, as long as you're well organised and well informed from the get-go, the actual process is relatively painless.
Yeah, that's been my experience, and I've had to talk any number of clients over the years out of making decisions whereby they're trying to avoid the planners. And this gets onto permitted development rights, where some people will think, well, they've heard about permitted development and they think this means I can do certain things and not have to go anywhere near the planners, which isn't strictly correct, because when the system was brought in, at least up here in Scotland, we've been advised that a homeowner should still get a certificate of lawfulness. I think it's called a certificate of lawful use down south. It's the same idea. Whereby we draw something that complies with the rules of permitted development, and then we send it off to the planners to say, does this in fact have permitted development rights? Can we get a certificate of lawfulness? But I've had so many people who are just, oh no, I don't, what will the planners think? Oh, terrified. But I mean, I only maybe get one refusal every 2 years or so, give or take. So when it does happen, it's a problem and it has to be dealt with, which is why I have a planning consultant that I will talk to about it. But most of the time we're okay. A lot of what happens is in the grey area, where there's negotiations back and forth, and the planning department will call me and we have a bit of give and take. A lot of people in the general public seem to be frightened of the planning system and convinced it's this impenetrable thing for most of the time, 95% plus of the time, it works okay for me.
I put it down to sort of a mix of the aforementioned sort of publicized horror stories of the planning system, which, as I said, are always more commonplace than the success stories in terms of their placement in the media.
And one thing that's come up a handful of times in my career is people who are deliberately trying to game the system. I had one guy who owned a farm in a rural part of Scotland and wished to convert a farm building or part of a farm shed into his home office, but we were designing it such that it could be used as a home. So it had rooms in it that could be bedrooms and a bathroom and a kitchen. And he thought that if he did this and it was exempt for a number of years, he could then turn around at a later date and say, aha, I've been using it as a home for 10 years or whatever. It's now a house and there's nothing you can do to stop me. And I had to tell him there and then, I don't know where you get these ideas from. That will never work. If you were trying to pull the wool over the planner's eyes, they will know, they will catch you, and they can have that thing demolished.
The cloak and dagger approach becomes more difficult as time goes on for multiple reasons. So firstly, there is a requirement in the first instance to get a degree of permission for that build development. So, and then a lot of the time there's a need to get building regs off the back of it. So you end up in a position where you're delineating a space, and when you're delineating a space, it quite often strikes a planning consultant or a planning officer quite early on as to whether that space could be for another use, and that obviously provides
they're
a
not
degree
stupid, you know. They
that provides a degree of wariness, I think, in terms of the issues. But I think it's the technological advancements, right? So we're in a position now where sort of drone footage, Google Earth, etc., Google Street Scene, they mean that the land is being recorded in 3D view on an almost yearly basis now. Yeah. And I know for a fact that enforcement officers, whose job it is to identify where things are being built without permission or being used in the wrong way, use that as a starting point, because why wouldn't you? It's the most efficient way of determining what's being built in an area on a year-by-year basis. So actually it becomes very difficult to try and do something in a cloak and dagger manner. And I would work on the assumption that the vast majority of the time, especially when you're trying to take advantage of that sort of 10-year rule or 4-year rule in other circumstances, it's not successful. We get approached a lot in terms of seeking to appeal enforcement notices when it comes to that sort of approach. And the vast majority of the time, there is a requirement to provide a degree of substantive evidence to support how something's being used. Yeah. And often, even in a scenario where someone's being quite prepared, they haven't done it to the required standards. So no, I wouldn't recommend it. I think it's much more straightforward, albeit I appreciate there are exceptions to this, to try and take forward a scheme that can either accord with planning policy, overcome planning policy, or make use of permitted development rights for development that may otherwise not get planning consent. So that's what it's there for.
Yeah, I mean, I always tell people, just as soon as you think you might want to do something, talk to someone like me, maybe yourself, and figure out what the rules are and try and work within the rules. It means the system is there to allow development. If they're considering a site and thinking, I'd like to build a house there, what should they look for?
Agree. The first thing that should always happen is a degree of risk assessment to be undertaken before any purchase of land is had. I suppose at the same time, when it comes to the speculative risk, the balance should be that the land value should be reflective of the speculative risk to a certain extent. I think the predominant issues is where someone's bought a parcel of land on an expectation of hope value, so there's an increased value that it will get planning consent when there's no chance to, which is becoming more and more of an issue. But in terms of how you determine where or where not you can't build, it comes down to a few key aspects, really. I think firstly, it's an understanding of designations, right? So some land outside of defined settlement boundaries, where the vast majority of development should occur, is open countryside, and that's it, right? So its entire limitation of development is just the fact that it's not in a settlement boundary. Yeah. But in other circumstances, the land is greenbelt, where there is this sort of stringent policing of the impact of development upon the countryside itself. There, some places are national parks, some are areas of outstanding natural beauty, and those sort of designated areas, are ultimately greater protected than than any others. So as a starting point, you would say, okay, well, if it carries that extra degree of protectionism, then that's a problem. That's not an area that would statistically be likely to get planning consent. And then beyond that, it really comes down to common sense a lot of the time. The physical layout of the land, how close it is to the services and facilities of local settlements, how isolated it is. Could you develop a property without offering substantial impact upon the landscape? And then ultimately, it's very site-specific planning aspects. You know, does the council have an issue in terms of their housing supply? Is there a shortfall in downsizing development in family homes? Is there a supporting policy locally for green principles, for net biodiversity gain, etc.? So it's very site-specific, but starting point is ultimately, how isolated is it? How far away is it from a local settlement? And does it carry any designations that just mean you've got no chance?
Yeah. No, and once you get beyond that, you've still got things like, say, visibility splays for joining the public road. That can kill a site stone dead. Like, even if everything else is working out, if you can't make that work, it's just not going to happen. Ransom
100%,
yeah. I've seen ransom strips scupper major developments. You suddenly find that you don't own the ground between your site and the road, someone else does, and they bought it deliberately to try and catch someone out when they're trying to develop. Getting your drainage, if you can't connect to a public sewer, then you need a septic tank, and you need certain amounts of space around a septic tank, and it's a practicality. It's not a planning application thing, but that can cause problems if someone's looking to buy a very small site. There just won't be enough space.
No, it all leads to this understanding as to why the vast majority of development occurs within these imaginary settlement boundaries. It is that is where the infrastructure is, and that is meant to be where development can occur without substantial compromise. There are exceptions. A lot of those exceptions are down to other factors, such as a huge requirement for need, often with local housing, affordable housing supply in general, or it could come down to being able to bring something forward which is architecturally exceptional. But in the most cases, most housing will be delivered inside of these sort of arbitrary lines around town, cities and villages.
Yeah. Back to that point about architectural exceptionalism, I can think of 2 council areas near me in Scotland who have that on the books as one of the qualifying criteria they would look for if you were building a one-off house in the country. And some very notable, well-respected architects have designed houses that have been knocked back, refused permission, and it's like, oh, well, if they can't get it, who can? And the other one that a few councils here do, I don't know if this happens down south, is called clustering, where if you have 3 or more homes existing within 100 meters of each other, it's easier, not guaranteed, but easier to get permission to add one more home to the cluster.
The terminology in Scottish planning policy is slightly different, but it's the same principle. So so clustering is essentially the same as what's called the test of isolation in England and Wales. Similar sort of scenario. The idea being that if you're proposing to bring forward a house within an area where there are existing houses, the sensitivity of the land is reduced. So the idea is that you could deliver a house without offering any greater impact upon the area. Yeah. The difference is, I think, that because Scotland is substantially more rural in terms of the settlement spread and settlement provision, the sensitivity levels are slightly lower. So the idea being, the notional cluster may be 3 in Scotland. In a lot of areas in England or Wales in particular, it will be 6 or 7. But it's the same principle. In terms of the architectural exceptionalism, that's a tricky field.
Yeah.
It ultimately requires, in the vast majority of cases, it requires an independent design review panel to determine that a development can be considered to be outstanding or innovative or a combination of both. And only then can you really take on board a planning application and have a very decent chance of obtaining planning consent. But as you'll appreciate, when it comes to architectural design, subjectivity still plays a part. So even with the design review panel supporting your case, it still may not get through that process. So it's a very tricky path, exceptional architectural design. And
it's one thing when you have, like you've described, an expert review. That's fine. Most architects can live with that and can probably target that. But when you, here in Scotland, and I suspect in England too, when you have developments above a certain size, or if they're of a certain category or sensitivity, they go before the local council planning board. So you have a local politicians voting as to whether or not to accept this. So if the planning officer thinks this is good enough to be acceptable, it has to still be put to a vote by local politicians. And like, there is no way of guaranteeing that that's going to work. There are any number of stories my colleagues here have of politicians just deciding on a whim, I don't like that, not going to vote for it, and it doesn't go through. So
it's a fundamental issue with the planning system in general. It's the fact that in a substantial number of circumstances, it is ultimately untrained representatives of a local authority that will determine whether a case succeeds or not, irrespective of what are meant to be the determining decision officer's recommendations. It's a huge problem.
What do you think the current problems are with the planning system, Chris?
So in terms of the infrastructure, clearly the issue is the lack of support for local planning authorities and lack of staffing making up those authorities, never mind the quality of them. I'm not a local authority apologist. If you don't satisfactorily provide budgets to local planning authorities, you're not going to get the quality of staff in order to raise the standards that could be expected within those authorities. And as a result, you're always going to get issues in terms of standards, whether that be in terms of the time frame, whether that be in terms of decision making or communication.
And it's got worse since COVID up here.
It's got a lot worse. I think that's a combination of the workforce reducing. There's a substantial amount of early retirements that took place. I think a lot of people who had worked for a long time in local planning systems had a lot of time to reflect and decided they were done.
Don't get me started. One of the main local authorities I deal with, it used to be that when you registered your application, you got allocated an officer and they would give their email address in a letter. Now it's just the home. They've just got a team. You're just being told a certain team.
Yeah, it's just a generic
team. You cannot then contact anyone and get a hold of someone to get an answer if they're not.
It's a problem. But what we will see down the line, and we're starting to see the effects of it now, is a lack of development, a lack of housing supply in particular, and that causes a problem. So then on top of that, you've got this issue in terms of the infrastructure, the decision-making infrastructure, but then on top of that, you have a lack of real solid requirements to force authorities to have up-to-date local plans in place. So you'll have authorities that have a huge requirement for housing, have no plan to actually deliver that housing, but have no policies in place that encourage the delivery of housing either. And due to what appears to be resistance in the political system to push things along, or perhaps listening to objections too much from certain areas, they're not in a position to actually push on with a plan. The trouble is that there isn't any mechanism presented by central government at the minute to really punish those authorities that fail to deliver local plans. There's plenty of encouraging words. There's nothing actually fundamental that would discourage an authority from proceeding with preparing a local plan if there's political issues with it. So
can I just touch on the political issues there? Because obviously, we've lived over the last few years through an era of quite a lot of political upheaval, and big things that everyone thought were quite permanent were changed. And at least I occasionally see people in the media, often in the fringes, advocating for the idea that, if we just got rid of the planning system's this barrier, it's getting between us and being able to build, whatever we want to build. That's probably never going to happen, touch wood. But can you imagine what would occur if that did happen? If someone said, you know what, either the planning system's gone or a certain chunk of it is gone, certain kinds of houses, if you own the land and have the money, you can start construction tomorrow morning. Because we did used to have a system like that if you go back far enough in history. My view is that if you could start construction tomorrow morning, by tomorrow lunchtime, there's going to be a high court injunction. People will go to the courts to get things stopped. And then you'll have people who know politicians getting early day motions and private members' bills through Parliament to get individual buildings built, because that's how most of the stately homes in this country are built. There's an actual act of Parliament for, say, Chatsworth House and other of the grand homes and large expansions to towns in this country. Am I right? That's what's going to happen. If you did get rid of the planning system, you'd essentially wind up clogging up the courts.
Yeah, so there's essentially, if you get rid of the Town and Country Planning Act, it doesn't remove any of the other legislative mechanisms that would restrict or challenge development within the UK, whether that
there are older acts of parliament as well.
There are plenty. There are matters associated with landholding and conveyancing, but beyond that, even more closer to home, there is the Environment Bill. There is the Planning, Listed Buildings and Conservation Areas Act. There is. It would be very difficult to untangle ourselves from a system that requires a degree of planning control. So planning reform in one form or another would help. A zoning system is problematic in general for multiple reasons, because it fails to give enough of a degree of specificity with regard to what could occur within certain locations. But a simple understanding of a time frame that could be presented to a local planning authority to say, okay, well, this is your objectively assessed need for housing across this next 5-year period. You have 6 months in order to allocate land that would otherwise be acceptable against all of these different legislative methods to make sure you deliver that housing. You have 6 months to do it from now. If you don't, we will do that ourselves as a central government mandate over the course of the following 6 months afterwards. So I think I personally think it's just a requirement to force authorities to be more aggressive with the delivery of housing, rather than any need to substantially overcome or remove the legislation that's there.
Yeah, the government down south has put forward the idea of giving neighbours or local communities more of a say in the planning system. I don't know if it's particularly well fleshed out, but it's an idea that's been put out there. Who knows with the current chaos in Westminster whether that's actually going to come to pass. But from your point of view, do you see pros and cons with this, or is it just all cons?
So I'm of the opinion that it's everyone's democratic right to have a say in what goes on in and around their area. I think that's a good thing.
Yeah,
I think
but that already happens.
Yes, yeah, and I think that's fine and fair. I think when it comes to the localized nature of planning, I think that's probably as effective as it's going to be in the current system, which is this idea of neighbourhood plans. So this gives a local area an opportunity to set a framework that has to go through a degree of scrutiny and auditing with regard to its accordance with its own planning policy, whether it's concise enough to be used as part of the development plan, etc. And it forces an area to be proactive rather than resistant to future-proofing themselves, which is a requirement. We simply can't stand still.
So it can't be a NIMBY's charter of no building here.
Well, to a certain extent, it can resist development, but it has to justify it. So it's not a case of you cannot bring development here, full stop. There has to be an understanding of it. So if you were, for example, trying to resist the provision of housing development within a town, let's say, your justification would be that in terms of the proportion of housing that this town has taken on in the past development plan period, it's an over subscription. So it's time for somewhere else to deliver it. But you need statistical evidence to balance that out. Neighbour plans are effective because they go through a degree of audit and control. They carry a degree of review by the planning inspectorate to make sure that they are robust in terms of their use. So it provides a mechanism to give people a voice. They're able to provide very area-specific opinions on development, which I think is helpful, because I think otherwise, decision makers at a regional level may not understand exactly how that particular area ticks, where the key aspects of it are. So I think that's important, but it's within the framework of something that is legislatively sound, and I think that's important.
Fair enough, because it's like, as with any of these things, you can keep some of the people happy some of the time, but you're never going to keep everybody happy. There will always be someone who feels this is either going too far in one direction or another. If you are thinking about altering or extending your home, or even buying a site to build on, you can book a consultation with me on the reallifearchitect.co.uk website. I've put a link in the description below. Thanks for watching, and please subscribe to get more content like this.